Hello everybody, today we want to show you a constitutional court of the Republic of Armenia.
1991, moreover, the Armenian Legislative Act considered setting up a constitutional court, although it never actually did so. Two laws, namely the law on the President of the Republic of Armenia, adopted in 1 October 1991, and the law on Supreme Council of the Republic of Armenia of 19 November 1991, simply alluded to such a constitutional court. However, no law or amendment to the Constitution of the Armenia USSR was ever adopted to put this declaration of the intention into effect. The new constitution, promulgated by the referendum on 5th July 1995, finally set up the Armenian Constitutional Court. The law on Constitutional Court was adopted by the National Assembly on 20 November 1995 and signed by President of the Republic of Armenia on 6 December 1995. On 5 and 6 February 1996, the members of the Constitutional Court were appointed and the court began operating on 6 February 1996. When its members were sworn in before the National Assembly, in 2005, constitutional reforms took place in the Republic of Armenia. In 2005, November 27, the text of the Republic of Armenia Constitution with the amendment was adopted by the referendum. The amendments directly concern the system of constitutional justice. Firstly, Article 93 of the Constitution enshrined the Constitutional Court shall administer the constitutional justice in the Republic of Armenia. According to Article 94 of the Constitution, the powers, the procedures of the formation and the activities of the court shall be defined by the Constitution and law. As the result of constitutional amendments, the scope of persons applying to constitutional court, as well as the scope of the objects of constitutional control, was substantially extended. The Institute of the Individual Constitutional Competent was established in the Republic of Armenia, Article 100.6 of the ERA Constitution.
The members, including the President, discharge their duties until the age of 65. According to transitional provisions, namely Article 117, paragraph 14 of the Republic Armenian Constitution, the incumbent members of the Constitutional Court shall continue to remain in office until the age of 70 years. The National Assembly and the President of the Republic are jointly empowered to appoint members of the Constitutional Court. 5 members of the Constitutional Court are appointed by the National Assembly upon the recommendation of the Chairman of the National Assembly. The other 4 members are appointed by the President of the Republic at his or her discretion. The President of the Constitutional Court is not elected by the members of the Constitutional Court. He or she is appointed from the court membership by the National Assembly on a nomination from the Chairman of the Assembly. However, if the National Assembly fails to appoint the President of the Constitutional Court within 40 days after the office of the President of the Constitutional Court is vacant, the President of the Republic must do so in its place. Persons fulfilling the following conditions are eligible for membership of the Constitutional Court: citizens of the Republic aged at least 45 who holds electoral rights and does not have citizenship of any other country, higher legal education qualification or an academic degree in constitutional law, at least 10 years legal work experience, command of the Armenian language. Members of the Constitutional Court may not be engaged in any entrepreneurial activity, nor shall he or she hold any office in state or local self-government body not related to his or her duties, hold any position in commercial organization, as well as engage in any other paid occupation except for scientific, educational, and creative work, which shall not hinder from fulfilling the duties of the member of the Constitutional Court. The constitutional principle is that a member of the Constitutional Court cannot be dismissed. Decisions to dismiss a court member must be taken by the person or body, for example the President of the Republic or the National Assembly, in the latter case by a majority vote of the total number of deputies, having appointed the member in question. Where such a question has been raised, the Constitutional Court must consider the case in the member's absence and must issue a conclusion on the termination of the member's office by a majority of at least 2/4 of the court membership, for example 6 out of 9. Once the conclusion has been issued, the actual decision on the Constitutional Court member's dismissal must be taken by the authority having appointed him or her, although in fact no member of the Constitutional Court has ever been dismissed since its inauguration. The independence of the members of the Constitutional Court is guaranteed by their submission to the Constitutional and the law on the Constitutional Court. It is prohibited to influence a member of the Constitutional Court, and anyone attempting to do so is liable to prosecution.
The powers of Constitutional Court. The Constitutional Court shall, in conformity with the procedure defined by law, determine the compliance of the laws, resolutions of the National Assembly, decrees and orders of the President of the Republic, decisions of the Prime Minister and bodies of the local self-government with the Constitution. Prior to the ratification of international treaties, determine the compliance of the commitments stipulated therein with the Constitution. Resolve all disputes arising from the outcomes of referenda. Resolve all disputes arising from decisions adopted with regard to the elections of the President of the Republic and deputies. Declare insurmountable or eliminated obstacles for a candidate for the President of the Republic. Provide a conclusion on the existence of grounds for impeaching the President of the Republic. Provide a conclusion on the incapacity by the President to discharge his or her responsibilities. Provide a conclusion on terminating the power of a member of the Constitutional Court, detaining him or her, agreeing to involve him or her as an accused, or instituting a court proceeding to subject him or her to administrative liability. Provide a conclusion on the grounds to discharge the head of community. In cases prescribed by the law, adopt a decision on suspending or prohibiting the activities of a political party.
Determined by Article 101 of the Constitution, shall appeal to the Constitutional Court in the order prescribed by the Constitution and this law. Moreover, in the cases determined in paragraph 6 of Article 101, legal persons are also eligible to appeal to the Constitutional Court according to Article 42.1 of the Constitution. Article 26. The Constitutional Court reviews the cases only if a relevant application exists. Article 27. First, the application is submitted to the Constitutional Court in written, signed by authorized person or persons. Second, the application shall include name of the Constitutional Court, name, title, the address, legal address of the applicant, required information of the representative of the applicant if the applicant is being represented, article of the Constitution that gives the right to an applicant to apply to the Constitutional Court, request submitted to the Constitutional Court and the argument of the applicant with the references to the relevant articles of the Constitution, list of documents attached to the application if such exists. Third, in cases determined by Article 69 of this law, the applicant is also obliged to submit to the Constitutional Court the receipt of the paid state duty in the amount prescribed by the law or a motion of release of such a duty. Article 28. First, the attachment of the application submitted to the Constitutional Court are power of attorney or any other document that certifies the authority of the representative, the Armenian translation of all the documents in foreign language certified in order determined by law, official text of the argued legal act in cases of appeals regarding the issues determined by paragraphs 1 and 2 of Article 100 of the Constitution, other materials that applicant finds appropriate. Second, after the admission of the application, new materials can be represented only by the permission of the Constitutional Court.
Since the first year of its formation, the Constitutional Court has become a member of the European Commission for Democracy through Law of the Council of Europe. 1 year later, in October 1997, the International Organization Conference of the Organs of Constitutional Control of the Countries of Young Democracy has been established, the activity of which is coordinated by the Constitutional Court. And in 2000, when Armenia was not a member of the Council of Europe yet, the Constitutional Court of the Republic of Armenia was elected as a full member of an international organization, Conference of European Constitutional Courts. Yves Guéna, president of the Constitutional Council of France, estimated this unprecedented effect very specifically. The Constitutional Court is already a successful institution, and it has become the full member of the conference due to its active participation and numerous interesting and real proposals. The organization of the annual Yerevan International Conference in cooperation with the European Commission for Democracy through Law of the Council of Europe has become a new tradition. Each conference was differing from the previous one by its actual topic and the large number of participants. And so a large number of well-known and authoritative lawyers and constitutionalists participated in the 5th Yerevan International Conference. All presented reports, discussions, and analyses of the topics of the conference have been published in the four language International Almanac Constitutional Justice in the New Millennium and are placed on the Constitutional Court website, which, by the way, is recognized as one of the best in the world. This unique program package, translated into Russian and English, is a concise material for constitutionalists and constitutional courts. The RA Constitutional Court has elaborated a complex program of comparative analysis of the international official documents, where 1,500 documents adopted by the United Nations and all international European institutions are included. The studying and analyzing and decision forwarding processes of the experience of the European Court and the materials of the European Convention on Human Rights have already finished.
Venice Commission established in May 1990 by 18 Council of Europe member states. In 2014, 60 member states, including 12 non-European members and Kosovo, with a total population of more than 1.5 billion people. On 1st November 2013, the President of the Constitutional Court of Armenia, Mr. Gagik Harutyunyan, in his quality of coordinator of the Professional Commission for the Constitutional Reforms and on behalf of the President of the Republic of Armenia, requested the assistance of the Venice Commission in the process of revision of the Constitution of Armenia. A specialized commission on constitutional reforms was formed by the decree of the President of the Republic of Armenia as of 4 September 2013, based on the necessity for implementing the principle of the rule of law, guaranteeing the basic human rights and freedoms, for ensuring the complete balancing of powers and increasing the efficiency of public administration. Having analyzed the historic process of constitutional development in the Republic of Armenia within the framework of systematic integrity as well as its key peculiarities and the existing problems, the Specialized Commission on Constitutional Reforms considers it necessary to highlight the following main stages in terms of conceptual approaches. In view of the international constitutional developments and the Armenian constitutional culture, we have still not found safeguards for ensuring stable development of constitutional legal relations. As a constant and continuous process, institutional developments have taken place in the international practice in line with the developments of society in the following main ways: adoption of new constitutions, amendments and additions to the existing constitution, consistent and coordinated constitutionalization of legal acts and the law application practice, adoption of organic or constitutional laws, official control of the constitutional provisions, resolution of disputes arising between the bodies of government in matters of constitutional powers.